The congressional hearing room fell silent as Jasmine Crockett rose from her seat, legal documents firmly in hand. Just moments earlier, Alan Dershowitz had cut her off mid-sentence with a sharp, "That's completely wrong on the law, Congresswoman." His interruption had sent murmurs rippling through the packed chamber. Now, Crockett stood confidently, her expression calm but determined, holding up a document that nobody, especially Dershowitz, expected her to have. "Professor Dershowitz," she began, her voice clear and measured, "before you interrupted me, I was about to cite the exact same precedent you wrote about in your 2003 Harvard Law Review article, which directly contradicts what you just told this committee." The room erupted in gasps and whispers. Dershowitz's face, previously animated with certainty, froze in a moment of unmistakable surprise. This wasn't just another congressional exchange. It was the precise moment when Jasmine Crockett, the freshman representative from Texas, turned the tables on America's most famous constitutional lawyer. If you're watching this video, hit the like button and subscribe now so you don't miss our next dramatic political showdown. To understand the weight of this confrontation, we need to recognize who these two legal minds are and the high stakes of their clash. Alan Dershowitz had built his reputation over decades as one of America's most prominent legal scholars and defenders of civil liberties. At 85, the Harvard Law professor emeritus had represented clients from O.J. Simpson to Donald Trump. With his sharp mind, trademark New England accent, and unwavering self-confidence, Dershowitz had become a fixture on television and in courtrooms nationwide. His books on constitutional law were required reading in law schools, and his opinions, however controversial, commanded respect. Dershowitz had arrived at the congressional hearing with his usual authoritative presence. Dressed in a crisp navy suit, he came, prepared to defend his interpretation of executive privilege with the certainty that had defined his career. For decades, his legal opinions had rarely been successfully challenged in public forums. When he spoke, committees listened. When he wrote, courts cited his work. This reputation for legal brilliance had made him accustomed to deference, especially from younger attorneys and politicians. Jasmine Crockett, at 42, represented a new generation of leadership. The freshman congresswoman from Texas brought her own impressive credentials to the table. Before entering Congress, she had built a sterling reputation as a civil rights attorney in Dallas, winning complex cases and establishing herself as a fearless advocate. Her legal background included work as a public defender and as counsel in high-profile police misconduct cases. Though new to Congress, she had quickly distinguished herself in the House Judiciary Committee with her precise questioning and legal acumen. Crockett had prepared meticulously for this hearing on executive privilege. For 3 days, she and her staff had pored over constitutional precedents, including Dershowitz's own extensive writings. While others might have been intimidated by facing Dershowitz, Crockett had approached the hearing with quiet confidence, bringing folders of research organized by colored tabs preparation that would soon prove crucial. The hearing room itself added gravitas to the confrontation. The mahogany panels, the imposing committee dais, the American flag standing tall, all created the perfect backdrop for this clash of legal minds. Journalists filled the press area, and every seat in the public gallery was taken. The significance of the issue at hand, the limits of executive privilege in congressional investigations, had drawn national attention. In the days leading up to this hearing, tensions had been building. Dershowitz had appeared on cable news programs, arguing forcefully that the committee's demands violated constitutional protections. Crockett had responded with a measured but firm op-ed asserting Congress's oversight authority. Their conflicting views represented a fundamental constitutional debate about the separation of powers, a debate that would now play out in dramatic fashion before the American people. What nobody anticipated was how thoroughly Crockett had studied Dershowitz's own past arguments that he himself seemed to have forgotten or chosen to contradict. This background set the stage for a confrontation that would soon captivate the nation and demonstrate that sometimes the most powerful weapon in politics is simply having done your homework. The committee room hummed with anticipation as Chairman Johnson called the hearing to order. Sunlight streamed through tall windows, illuminating the packed chamber where committee members sat behind their nameplates. Cameras from major networks were positioned strategically, capturing every moment of what promised to be a consequential hearing on executive privilege. Dershowitz testified first, presenting his case with the confidence that had defined his career. Leaning slightly toward the microphone, he spoke without notes. "The doctrine of executive privilege exists precisely for these situations," he declared, his Boston accent pronounced. "When Congress demands documents reflecting the president's private conversations with advisors, it strikes at the heart of the separation of powers. No president can function effectively if every conversation might be exposed. The Supreme Court has consistently recognized this privilege as fundamental to our constitutional system. Several Republican members nodded in agreement as Dershowitz continued, citing cases from United States versus Nixon to more recent precedents. For nearly 15 minutes, he built his argument methodically, occasionally glancing at the Democratic side of the dais with an expression that bordered on condescension. When questioning began, friendly exchanges with Republican members allowed Dershowitz to elaborate further. He grew increasingly comfortable, his gestures more animated. This committee's subpoena is precisely the kind of congressional overreach that the framers feared, he asserted, tapping the table for emphasis. When it came time for the Democrats' questions, Congressman Adams began with a respectful but pointed challenge. Dershowitz parried effectively, his responses rapid and authoritative. The pattern continued through two more Democratic questioners, with Dershowitz maintaining his composure and control of the narrative. Then came Congresswoman Crockett's turn. She began calmly, establishing the historical context for congressional oversight. Professor Dershowitz, would you agree that our system of checks and balances depends on Congress having meaningful oversight capacity? She asked. Of course, Dershowitz replied confidently, but oversight has constitutional limits. The executive privilege. I understand your position on executive privilege, Crockett interjected politely. But I'd like to explore how your current view aligns with positions you've taken in the past. A flicker of unease crossed Dershowitz's face, quickly replaced by his practiced confidence. My views on constitutional matters have been remarkably consistent over 5 decades, he stated. Crockett nodded, then reached for a document from her meticulously organized folder. In 1998, during the Clinton impeachment proceedings, you wrote that executive privilege cannot be invoked to shield potentially criminal conduct or to prevent Congress from performing its constitutional oversight function. Would you still agree with that statement? Dershowitz shifted slightly. The context was entirely different. The legal principle remains the same, doesn't it? Crockett pressed, her tone respectful but firm. Not at all, Dershowitz responded, his voice rising slightly. The current situation involves confidential policy discussions, not allegations of criminality. The distinction is fundamental to any serious constitutional analysis. Crockett remained unfazed. Let me turn to something more recent then. In your 2003 Harvard Law Review article titled Executive Privilege Revisited, you wrote, and I quote, "When Congress seeks information in service of its legitimate legislative function, executive privilege claims must yield unless disclosure would demonstrably harm national security." That seems directly relevant to our current discussion. Dershowitz leaned forward abruptly. You're taking that entirely out of context, Congresswoman. If you read the full article, I have the full article right here, Crockett responded, holding up a document filled with highlighted passages. Would you like me to read the 3 paragraphs that follow this quote? They further strengthen the case for congressional access. Murmurs rippled through the hearing room as Dershowitz frowned. That article was addressing a very specific historical situation. That's completely wrong on the law, Congresswoman. Dershowitz suddenly interrupted, his voice sharp. You're conflating separate constitutional principles and misrepresenting my scholarly work. Executive privilege exists precisely to prevent this kind of congressional fishing expedition. Your committee has no legitimate legislative purpose that would overcome this privilege. The room fell silent at his forceful interruption. Committee members straightened in their chairs. The chairman looked up, startled by the change in tone. This was the moment the interruption that would soon be replayed on news programs nationwide. As Dershowitz finished his statement, a subtle smile crossed Crockett's face. She stood slowly, gathering several documents. Professor Dershowitz, she began, her voice calm but carrying clearly through the silent chamber, since you've interrupted my questioning to claim I'm wrong on the law, I'd like to direct your attention to your own amicus brief in Department of Justice versus House Committee on the Judiciary, 2020. She approached the witness table, placing the document directly in front of Dershowitz. On page 17, you wrote that congressional oversight power reaches its zenith when examining potential conflicts between official duties and private interests. On page 23, you explicitly stated that executive privilege cannot be invoked as a blanket protection for all White House communications, but requires a specific showing of harm to national interests for each document withheld. Dershowitz stared at the document, momentarily silent. Crockett continued, "This brief was submitted just 3 years ago. Has your legal opinion evolved since then, Professor? Or does your interpretation of executive privilege change depending on which president is asserting it?" The chamber erupted in gasps and whispers. Democratic members leaned forward. Suddenly, alert, Republican members shifted uncomfortably. Journalists in the press section furiously took notes. Dershowitz adjusted his glasses, scanning the document before him. His usual rapid response failed him as he recognized his own words. "Congresswoman, legal analysis is nuanced," he began. "Yes, it is," Crockett agreed. "And your nuanced analysis in this brief directly contradicts what you're telling this committee today. You explicitly argued against the very position you're now defending." She returned to her seat but remained standing. "Professor, you interrupted me to claim I was wrong on the law. But it appears I was simply citing your own legal positions you've apparently abandoned. Can you explain this contradiction to the committee?" The camera zoomed in on Dershowitz's face as he struggled to reconcile his past writings with his current testimony. The constitutional scholar, who had never been at a loss for words, now paused, searching for a response that would preserve his credibility. The confrontation had reached its critical point. A freshman congresswoman had just used the legal giant's own words to question not just his argument, but his intellectual consistency, the very foundation of his reputation. The silence that followed Crockett's question seemed to stretch for an eternity, though it lasted only seconds. All eyes in the hearing room focused on Dershowitz, waiting for his response. When he finally spoke, his tone had changed noticeably. Gone was the commanding certainty that had characterized his earlier testimony. In its place was a more measured, almost defensive posture. "Congresswoman Crockett," he began, clearing his throat, "constitutional interpretation requires considering the specific factual context. The brief you cite addressed a fundamentally different situation. Crockett didn't allow the deflection to stand. With respect, Professor, both scenarios involve Congress seeking information from the executive branch about potential misconduct. The legal principles are remarkably similar. In fact," she continued, pulling out another document, "I have here your appearance on CNN from May 2019 where you stated that executive privilege cannot be used to shield potential wrongdoing from congressional scrutiny. That statement was made during a different administration, yet it directly contradicts your testimony today." The committee room erupted again. A journalist in the front row whispered audibly to his colleague, "She came prepared for war." Camera shutters clicked rapidly, capturing Dershowitz's increasingly uncomfortable expression. Chairman Johnson, recognizing the significance of the moment, extended Crockett's time. "The gentlewoman from Texas may continue," Crockett nodded gratefully. "Professor Dershowitz, you've built your career on being a principled legal scholar whose opinions remain consistent regardless of political considerations. Yet today, you're advancing arguments that directly contradict positions you've taken when different parties held power. This raises serious questions about the credibility of your testimony." Dershowitz attempted to regain control. "Congresswoman, I've written thousands of pages on constitutional law over my career. It's possible to find isolated statements that, taken out of context—" "These aren't isolated statements, Professor," Crockett interrupted, her voice still respectful but increasingly confident. "They represent a consistent pattern in your scholarship until recently. I have 7 separate instances, spanning 3 decades, where you argued that executive privilege must yield to congressional oversight in situations remarkably similar to the one we're discussing today." She held up a chart her staff had prepared, displaying quotes from Dershowitz's books, articles, and media appearances, all contradicting his current position. "This isn't about isolated statements taken out of context," she continued. "This is about fundamental legal principles that you've defended throughout your career, principles you appear to have abandoned for reasons I can only speculate about." Dershowitz, visibly flustered, shuffled through his papers. "Congresswoman, this is becoming a personal attack rather than a substantive legal discussion." "On the contrary," Crockett responded calmly, "this is entirely about legal substance. Your own scholarly work undermines the very arguments you're making to this committee. I'm simply asking you to reconcile these contradictions." The atmosphere in the room had transformed. Committee members who had been checking their phones or reviewing notes were now fully engaged, watching the unexpected duel unfold. Senior Democratic members exchanged impressed glances at Crockett's methodical dismantling of Dershowitz's arguments. Dershowitz, sensing his position weakening, attempted a new approach. "Congresswoman, even if you disagree with my current interpretation, many respected constitutional scholars share my view that this particular assertion of executive privilege is valid." Crockett was prepared for this pivot. "I'm aware of those perspectives, Professor. However, I have statements from 5 of the 6 scholars you mentioned in your written testimony. All of them have indicated that you've mischaracterized their positions. Professor Ackerman specifically stated yesterday that your characterization of his work was deeply misleading. She slid another document across to him, a letter signed by multiple legal scholars distancing themselves from Dershowitz's interpretation. The room buzzed as Dershowitz scanned the letter, his composure visibly cracking. Representative Jordan, attempting to rescue Dershowitz, interjected with a point of order, but the chairman overruled him, allowing Crockett to continue her questioning. "Professor," Crockett said, her voice now carrying an unmistakable authority, "would you agree that the legitimacy of our constitutional system depends on consistent application of legal principles regardless of which party holds power?" Dershowitz nodded, perhaps sensing a lifeline. "Of course, constitutional principles must be applied consistently. Then how do you explain your own inconsistency on this fundamental question of executive privilege?" Crockett asked, delivering the question with perfect timing. "The only variable that seems to have changed is which party occupies the White House." The impact was immediate and visible. Dershowitz, the legal titan who had confidently faced down the toughest judges and opponents throughout his storied career, appeared genuinely rattled. His response came slowly, his trademark eloquence momentarily deserting him. "I believe my positions have been consistent with the evolving jurisprudence on executive privilege," he managed, but his voice lacked conviction. Crockett moved in for the decisive point. "The jurisprudence hasn't evolved, Professor. The Supreme Court's position on executive privilege has remained remarkably stable. What appears to have evolved is your interpretation, conveniently aligning with your political preferences rather than established legal principles." She turned to address the chairman directly. "Mr. Chairman, I have no further questions for the witness. I would, however, like to submit for the record the complete collection of Professor Dershowitz's prior statements on executive privilege, along with the relevant court decisions demonstrating the consistency of judicial interpretation on this matter." The chairman nodded, without objection. As Crockett sat down, the hearing room erupted in murmurs and whispers. Journalists rushed from the room to file updates. Social media was already exploding with clips of the exchange. Dershowitz sat motionless at the witness table, the papers containing his own contradictory words still spread before him, a physical representation of a reputation momentarily shaken. The Harvard professor who had mentored generations of legal minds had just been outmaneuvered by a freshman congresswoman who had done something deceptively simple. She had read his work and taken him at his word. The victory wasn't just political, it was substantive. Crockett hadn't merely scored points, she had defended a principle central to constitutional governance, that power must be constrained by law, and that legal principles must apply consistently regardless of who holds office. In the press gallery, reporters were already crafting headlines. Crockett catches constitutional scholar in contradiction, and Dershowitz stunned by his own words. But beyond the dramatic moment, something more significant had occurred, a powerful demonstration that in the arena of ideas, preparation and principle could triumph over even the most formidable reputation. As the committee called a 15-minute recess following the explosive exchange, the impact of what had just transpired began to ripple outward. Capitol Hill staffers were already sharing clips of the confrontation on social media, and within hours, the video would be viewed millions of times. The phrase "Crockett catches Dershowitz" became an instant trending topic. In the hallway outside the hearing room, journalists surrounded Congresswoman Crockett, thrust suddenly into a national spotlight far beyond her previous media exposure. Standing poised before a forest of microphones, she maintained the same measured tone that had served her so effectively during the hearing. "This wasn't about embarrassing Professor Dershowitz," she explained to the assembled press. "This was about defending a fundamental constitutional principle. Congress has not just the right but the duty to conduct meaningful oversight. Executive privilege serves important purposes, but it cannot become a shield against accountability." When asked if she had expected Dershowitz to be unable to reconcile his past positions with his current testimony, Crockett's response was characteristically thoughtful. "I didn't come here looking for a gotcha moment. I came prepared to have a substantive legal discussion. I've respected Professor Dershowitz's work for many years. That's precisely why I studied it so carefully." The inconsistency in his positions raised serious concerns that needed to be addressed for the integrity of these proceedings. Meanwhile, Dershowitz was engaged in damage control. Surrounded by his own smaller group of reporters, the professor attempted to reframe the exchange. "Congresswoman Crockett is a talented attorney, but she fundamentally mischaracterized the nuance in my positions. Context matters in constitutional interpretation. Yet, even as he spoke, clips of the confrontation were being played on split screens beside his current defense. The juxtaposition of his contradictory statements, now circulating widely, made his explanation ring hollow. Several reporters pressed him specifically on his 2020 brief, which Crockett had presented during the hearing. That brief addressed a very specific factual scenario. Dershowitz insisted, but his explanation grew increasingly technical and defensive. When a reporter from the Washington Post directly asked if his view of executive privilege had changed depending on which party held the White House, Dershowitz abruptly ended the impromptu press conference. Back inside the hearing room as proceedings resumed, the dynamic had shifted noticeably. Republican members, who had initially deferred to Dershowitz with almost reverent respect, now approached their questioning more cautiously. Several chose to focus on narrow procedural aspects rather than the broader constitutional principles where Dershowitz's credibility had been damaged. Democratic members, emboldened by Crockett's effective questioning, pressed harder on the inconsistencies she had exposed. Congressman Liu from California built directly on Crockett's foundation, asking Dershowitz to explain a 2017 Law Review article where he had argued that executive privilege claims weaken significantly when Congress investigates conflicts between public duties and private interests. By the PERT Act. Hearing's conclusion, the narrative had been fundamentally altered. What had been intended as a showcase for Dershowitz's constitutional expertise had become a case study in the dangers of intellectual inconsistency. Chairman Johnson, in his closing remarks, noted pointedly that today's testimony has given this committee much to consider about the proper scope of executive privilege and about the importance of principled consistency in constitutional interpretation. The aftermath extended far beyond the hearing room. Law schools across the country incorporated the exchange into their constitutional law curricula. The confrontation became a textbook example of effective congressional questioning and the importance of thorough preparation. For Dershowitz, the impact was significant but not career-ending. His decades of legal scholarship couldn't be erased by a single congressional appearance, yet the exchange left a lasting mark on his public persona. In the months that followed, his television appearances decreased noticeably, and his opinions on executive privilege were now consistently met with references to the Crockett confrontation. Legal scholars debated the substance of the exchange in academic journals. Most concluded that, while Dershowitz's broader body of work on executive privilege contained valuable insights, Crockett had correctly identified a troubling inconsistency in his recent positions. The Harvard Law Review published a symposium on executive privilege that included an essay by a former Dershowitz student noting that the principles of constitutional interpretation should not bend to accommodate political preferences. For Crockett, the exchange became a defining moment in her congressional career. Her methodical dismantling of Dershowitz's arguments earned her respect across the political spectrum. Senior members sought her input on legal matters, and her committee assignments reflected her enhanced stature. Legal organizations invited her to speak about congressional oversight and constitutional principles. More importantly, the substance of her challenge eventually prevailed. 6 months after the hearing, the Supreme Court issued a ruling in a related case that largely aligned with the position Crockett had defended. The court cited some of the very same precedents she had raised during her questioning of Dershowitz. The ruling affirmed that while executive privilege served important functions, it could not be invoked as a blanket shield against congressional oversight. Beyond the specific legal questions, the confrontation entered the broader cultural conversation about expertise, authority, and accountability. Commentators noted how Crockett, instead of deferring to Dershowitz's impressive credentials, had engaged directly with his ideas and held him accountable for his own words, a powerful reminder that in a democracy, even the most respected voices must be prepared to defend the consistency of their positions. Perhaps most significantly, the exchange became a source of inspiration for a new generation of lawyers and public servants. Law school applications from young women of color increased noticeably the following year, with many applicants specifically citing Crockett's example as an inspiration. She showed that preparation and principle can stand up to even the most formidable authority, one applicant wrote in her personal statement. 3 years later, when Crockett introduced comprehensive legislation to clarify the boundaries of executive privilege, she invited Dershowitz to testify again. To the surprise of many, he accepted. Their second exchange was more collaborative than confrontational, a thoughtful discussion between two legal minds focused on strengthening constitutional governance rather than scoring political points. In her opening statement at that future hearing, Crockett would reference their first encounter with characteristic grace. Professor Dershowitz and I may have approached these questions from different perspectives. but we share a fundamental commitment to constitutional principles that transcend partisan interests. Our system depends on the tension between competing values, executive confidentiality, and congressional oversight, efficiency and accountability, power and restraint. Through respectful but rigorous debate, we strengthen the constitutional fabric that binds us together as a nation. The Crockett-Dershowitz confrontation thus became more than a dramatic political moment. It served as a reminder that in a constitutional democracy, principles matter more than personalities, consistency matters more than credentials, and the peaceful contest of ideas, when conducted with preparation and respect for truth, strengthens the institutions that preserve our freedom. As we've seen in this dramatic confrontation between Jasmine Crockett and Alan Dershowitz, preparation and principle can triumph over even the most impressive reputation. If you enjoyed this analysis of this remarkable exchange, don't forget to like this video and subscribe to our channel for more insightful coverage of the moments that shape our political discourse. Hit the notification bell to ensure you never miss our latest uploads. Share your thoughts in the comments below. What was your favorite moment from this confrontation? See you in our next video.